Hi everyone, welcome to my channel The Commerce Tree. I am CS Ridhva Mishra and today we are going to start a very fresh topic under the company law, that is the classification of the companies under the Companies Act 2013. Okay, I have already told you about the introduction of the companies. What is a company? What are the essential and what are the features of the company? Okay, so today we will be moving forward with the classification of companies. It means up to how many division or how many classes the company has been divided under the Companies Act 2013. Okay, and so before starting the class, please do share and subscribe my channel The Commerce Tree, and for the new notification whenever I upload my video, please click on the bell icon. Okay, so the classification of the companies under the Companies Act. First of all, we'll learn the provision of the act shall apply to the companies which are incorporated under this act, means the company which are incorporated under the Companies Act 2013. Second, the insurance companies which are registered under IRDA Act 1999 and the Insurance Act 1938. Third come the banking companies, which comes under the Banking Regulation Act 1949. See, every type of a company has its own regulation, but the wholesome regulation under which the Company Act is the Companies Act 2013. Fourth come the companies engaged in generation of the supply of electricity. Okay, or any company just like the Electricity Board of India, which comes under the Electricity Act 2003. Fifth, any other company governed by any special act for the time being in force, or such body corporate which are incorporated by any act which is governed by the central government. Any company which is formed and governed by the central government. So these all provisions, whatever I am going to tell you in the class, these all provisions are applicable to these kind of companies only. Now come the classification of the companies. So companies are divided on the basis of members, on the basis of liability, on the basis of control, on the basis of access to capital, and the other type of companies. Okay, first of all, we'll be learning about the companies divided on the basis of members. Means how many members will be there in a particular type of a company. First come under section 2 subsection 68 a private and a public company. Public company, section 2 subsection 71. It is not necessary in the exam to write these sections. Please do not write the wrong section. Always write the correct section. If you are not confident, please do not write in the exam. So first of all, we learn about the private company. Private company are divided into three type of company more. Okay, one is a one person company, second is a small company, and third is a other type, which means the remaining of the private company which do not come under the category of one person company and a small company. Okay, so moving further, let's have a brief introduction, or you can say a brief description about the what is a one person company, what is a small company, and which type of a company will come under the other private companies. Okay, as you can see, OPC, one person company, it is the smallest private company, you can say, because it is the company which is started by the one person company, one person. Okay, maximum one person, minimum number of members should be one, and the maximum number of members should also be one. It cannot go two. If there are two members in a particular company, then it will come under the category of small company and the other company. Okay, so in the OPC the members are one. Under the small company, the minimum numbers are required to be 2 and the maximum are 200. The number of members cannot go beyond 200 members. In the other private companies, the minimum are 2 and the maximum are 200. Now come the share capital. Okay, so there are certain changes under the small company. There was a recent amendment which came, and it can come into exam, that what is the maximum share capital Okay, in the case of the OPC and the small, this maximum share capital questions come. What is a maximum share capital under the OPC? What is a maximum share capital under the small company? So when it comes to the OPC, the minimum share capital, there is no limit. A company can also be start with the 100 rupees. And the maximum share capital up to which it can go is 50 lakh in the case of the OPC and 2 crore in the case of the small company. Okay, this is the amended one. And in case of the other company, there is no limit. There is no limit of maximum share capital. Now come the director. There, in the case of the OPC, when the member is one, so the director will be also one only. In case of small company, there should be minimum 2 directors. Okay, so you can relate the minimum number of members with the minimum directors. Okay, in case of the other private companies, there should be minimum 2 directors. Now the second question, the most important question comes, the turnover one. In the exam, it may be asked what will be the turnover of the OPC, of the small and the other company. So in case of the OPC, the maximum turnover will be 2 crore. In case of small company, 20 crore. And in the case of the other company, there is no limit. Now come the difference between the private and the public. In the previous slide, we read about the types of the private company, which is divided into 3 parts: OPC, small and other private company. Now we will be reading about the difference between the private company and the public company. Okay, so in a private, let's move further. In a private company, is there any share capital required? Minimum share capital. Now here the private company, we are taking the others category. Okay, so is there any minimum capital? No, there is no minimum capital in the case of a private company. But yes, in case of the public company, there should be 5 lakh minimum capital. Then only a public company can be incorporated. Now come up the members. Minimum members, 2 members should be there in case of the private company. In case of the public company, there should be at least 7 members to start a company. Okay, maximum, there is a limit in the maximum. In case of a private company, there should be 200 members, but in case of a public company, there is no limit. They can be 1 lakh member, they can be 2 lakh member, they can be 1 crore member. So there is no limit in the case of a public company. When it comes to the directors, there should be minimum 2 directors in case of the private company, and there is also the maximum limit that a private company can only have 15 directors, not more than that. A public company, it comes to the public, so the minimum number of directors should be 3 in number, and there is no maximum limit of the director in case of a public company. Now come the transferability of the shares. Okay, what is the transferability of the shares? It means whether the shares can be transferred from one member to the other member. No, in case of a private company, no share can be transferred from the one member to the other member. If I am holding a particular share, I cannot transfer to you. But in case of a public company, the transferring of the shares goes on. There is no restriction on the transferability of the share. The shares can be easily transferable from the one member to the other member. Now come the invitation to public for subscribing shares. Now understand this, invitation to public. So in case of a private company, private means closed group, there is no public involvement, so the no invitation can be given to public for subscription of shares. But in case of a public company, there is no restriction. You can freely invite the public to subscribe the shares. Okay, now come the one person company. Now we'll go in the detailed manner what is a one person company. Again, revision. One person company means a company which is incorporated by the one person as a member. There should be one member, there should be one director. What is the minimum capital? What is the maximum capital? Minimum capital 0, maximum capital 50 lakh rupees, turnover 2 crore rupees. Okay, so it is described under the section 3 subsection 1 class C as a private company. Yes, it is a type of a private company. So OPC differs from the sole proprietor concern in an aspect that OPC has a separate legal identity. This is a great question, that whether the OPC is a sole proprietorship. Any layman can ask you that OPC act just like a sole proprietorship. You can say no, because it is a type of a private company, so it act under the Companies Act 2013, in which it has been defined a company has a separate legal identity from its members, that it can enter into contract in its own name. Okay, so memorandum should also be subscribed by the one person, because there is one person and there is a one person as a member, but in case that one person dies, so for in that sake he has to appoint one nominee, that in case that person die, so that the person who is nominated as a nominee can act as a one person in a one person company, means he can hold that position of the one person member in a company. Okay, so yeah, the memorandum shall state that now comes the one person and about the nominee of the one person company. It states that the memorandum should have that clause, they should be written who will act as a nominee in case of a death of the member of a company. Understood? Now the member of the fourth point, the member of the OPC may at any time change the name of such person by giving notice to the company, and the company shall intimate the same to the registrar. It is not necessary that if you have nominated one person while the formation of a company, we cannot change the name of that person in future. No, we can change the name of a person in the future by giving a notice to the registrar that we require to change the nominee of a company, that in case if I die, then this person will act as a member of the company. Okay, now come again, that is a short points, that nominee, natural person excluding minor. See, why minor is not been considered as a nominee? Because go to the Contract Act, which says a minor cannot enter into any kind of a contract. It means a nominee should be a natural person excluding minor. He should be a major, he should not be a minor, because otherwise he will not be able to enter into any kind of a contract. He should be resident for at least 182 days. It's very important for him to be the resident of India. Natural person can be nominee of not more than one OPC. Okay, so one person can be nominee of one OPC only. He cannot get the nomination into two OPC, means one person company. Now come the one person company conversion into how many category one person company can be converted in case the capital increases beyond 50 lakh rupees and the turnover increases beyond 2 crore rupees, then the company has to convert itself into the private company. Okay, voluntary conversion under 2 years have elapsed since incorporation or exceeded its limits, so it has to mandatory convert itself into private company. It can be also converted into section 8 company. It cannot convert itself into section 8 company. Now come on the basis of liability. See, on the basis of liability means liability in Hindi we called it as कर्ज, the debt. Okay, so the company which is limited by liability, it means in case the company goes into the loss, the way it will fulfill its debt. So first come the limited by shares. It says when the liability of the members are limited up to the amount unpaid on shares held by them. In case if I have buy 100 shares and I have only paid amount of 50 shares to the company, so I'm only liable in case of the loss to the company, I'm only liable up to the 50 shares of the amount which I have not paid to the company. Okay, they will not take out the debt from my personal property. Now come the limited by guarantee. When the liability of the members is limited up to the amount contributed to the assets of the company at the event of winding up. If I have invested 1 crore in a particular kind of a asset of the company, okay, now it has come the now the winding up is going on of that company, so I am only liable up to that 1 crore that I have invested to that machine, invested to that asset of the company. That is a company which is limited by guarantee. Now comes the unlimited. Unlimited means beyond any limits. There is no limit of paying the debt. It means my personal property can be taken, can be acquired by the company to pay the debts of the company. Now come the on the basis of control. Control means the you can say the holding of the shareholding of the company. Any company holding, what is a holding company? Company holding more than 51% of the shareholding in other company and controls the board of director. If I am holding 51% of the shares in the other company, that is a holding company. So I am the holding company of that particular company. Subsidiary company, if any other company is holding more than 51% of shares of my company, so I am the subsidiary of the holding company. Means when a person holds 51% of the shares of the other company, that is a holding company, the 51% of the shares are held by the other company, so that company is the subsidiary company. Now comes the associate company. If I am having the significant influence in any of the company, it means if I am holding more than 20% of the share capital of any other company, so that means that company is an associate company, okay, holding at least 20% of the total share capital. Now come the company limited by guarantee and company limited by share. The difference between them I already told you. What is a company limited by guarantee? If I have invested 1 crore to an asset of the company, then at the event of winding up, I am only liable up to the 1 crore that I have invested to the asset of the company. Not a single extra amount I will be giving to the company to pay the debts of the company in case of a loss. Okay, so a company limited guarantee may or may not have the share capital. Okay, every member shall be liable to pay the amount that he has guaranteed to pay to the company in the event of winding up of a company. Understood the company limited by guarantee? Now come the limited by shares. What I told, if I have acquired the 100 shares, I have acquired the 100 shares, but I've only paid the amount of 50 shares to the company. 50 shares is still pending for me to pay. Okay, so I am liable up to that 50 unpaid shares that is held by me. That is a limited by shares. Now come on the basis of access to the capital. Listed and unlisted company which has listed any of its securities under the stock exchange. Okay, we say that that company is a listed company of India. It means that they have listed their shares under the stock exchange. And so one question, whether the private company can be listed or unlisted. The answer is no. A private company does not fall under this category because the private company cannot issue the shares to the public. Cannot issue the shares to the public. The public has no access to the capital of the company. Public only have the access to the capital in case of the public company. And a public company is divided into the two categories. A public company can be either listed or unlisted company. If it is listed on the stock exchange, it is a listed company. If it is not listed under the stock exchange, it is unlisted company. What is a stock exchange? It is a platform where the trading or where the buying and selling of the commodities and shares goes, where the issuance and the selling of the shares and the other commodities are carried out by the public and the company. What is a BSE? It is a Bombay Stock Exchange. What is a NSE? It is a National Stock Exchange. Now come the foreign company. What is a foreign company? See, no big question will be coming in case of the foreign company. Only the small question can come, or you can say any objective type question can only come. It says any company or a body incorporated outside India which has a place of business in India, whether by itself or through an agent, conduct any business activity in India. What is a foreign company? If a company is incorporated in India, it is an Indian company. But if a company is incorporated outside India, but it is carrying out the business in India or conducting any business activity in India, it is a foreign company. Now come the Section 8 company. Section 8 company is a very, very important company. Section 8 defines that any company which is formed to carry out any charitable object, any social work, any social welfare work, that type of a company falls under the Section 8 of the Companies Act 2013. Okay, social work, charitable object, it means it cannot make any profit. When we do any social activity, do we have any motive of earning profit? No, na. So like that only, a Section 8 company is a non-profit making company because it is incorporated to carry out a charitable objects relating the commerce, art, science, sports, education, etc. It should be related to the social welfare only. It prohibits any payment of the dividends or distribute profit. When there won't be the profit, there will not be any dividend, so it will not be able to distribute both of them. Central government has a license is issued to the Section 8 company. Who issue the license? Central government issue the license to the Section 8 company that yes, now you are good to go to carry out any charitable objects of the company. Now, a Section 8 company shall act as a limited company. Limited company that it enjoys the limited liability. Okay, no personal property is attached to the liability of the company. It can convert itself into any other kind of company by passing a special resolution at general meeting. This is an important point. Any other company cannot convert itself into the Section 8 company, but a Section 8 company can convert it itself into any other kind of a company by passing the special resolution in a general meeting. General meeting means a meeting which is held by its members. Now come the dormant company. Dormant means which are inactive company which are formed but are not carrying out any activity, not a dormant company. Nidhi companies, nidhi means dhan, daulat. Nidhi company which deals in the giving and taking of the money, which deals in the money, objects of saving money of its members, which act like a bank. You can say a saving bank. Okay, a company which act like a saving bank. So its motive is to receive the deposits and lending to the members only. It acts in accordance with the rules and regulation which are prescribed by the central government. RBI is involved, Reserve Bank of India. Now come the public financial institution. Who is known as a public financial institution? The company of which more than 51% of the shareholding or the capital is controlled or is held by the state government or the central government. Okay, the government company, which we say as a government company, that is a public financial institution. Why it is known as public financial institution? Because it is constituted or act in accordance with the Central and State Act of India. For example, Life Incorporation of India, LIC, and the Union Trust of India. So this was the end of our topic. I hope I made you understand the whole topic. Okay, so I will be also telling you about the important questions, the important topic. In case if you feel any doubt, please do comment on my video, and please do share and do subscribe it. Well, bye, take care, see you again with the next and fresh video.